All right, Mr. Schmidt, you ready? This is cause number CR 24-70, CR 22-220. I'm sorry, incorrect number. CR 24-70. State of Texas versus Charles Justin Howard. Is Mr. Howard entering the plea today?
Yes, sir.
All right, Mr. Howard, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony that you give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Is your name Charles Justin Edward Howard?
Yes, sir.
And Mr. Howard, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work he's done for you?
Yes, sir.
Do you have any questions about any of the paperwork that you've read over and signed today?
No, sir.
Mr. Schmidt, do you believe Mr. Howard to be competent? If so, have you explained to him his rights as they pertain to this case?
Yes, sir.
All right, I see here, Mr. Howard, that you are charged by indictment with a second-degree felony offense of burglary of a habitation. That does carry a potential range of punishment of not less than 2 years or more than 20 years confinement in prison should you be sentenced. I see the court also sees that you have a recommendation from the state upon your plea of guilty. They're recommending that the court not convict you of the offense, but rather place you on 5 years of community supervision with a $1,000 fine, $290 court cost, and $520 in reimbursement fees. Is that your understanding of the agreement, Mr. Howard?
Yes, sir.
All right. All right. Understanding the range of punishment, understanding the plea agreement, Mr. Howard, at this time, I'd ask you, how do you plead to burglary of a habitation?
Guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, court will accept the plea of the defendant. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
Stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Let me inquire, Mr. Hartwell, have you spoken with the victim in this case, and are they supportive of this plea?
Your Honor, we made attempts to talk to this victim, set up the victim impact statement. We have received nothing, no response to our attempts.
All right. Anything from the defense?
No, sir.
Okay, I do have to inquire about this plea only because I know that Mr. Howard's a multi-time convicted felon, and I'm not used to seeing 5 deferreds on burglary of a habitation with someone with the criminal history that Mr. Howard has. Any argument from the state why you think that Mr. Howard that our community is better off with Mr. Howard in it than him being disposed in some other way?
Your Honor, just from my time with the county, I believe Mr. Howard has spent some time on pretrial release and has not had any issues. Perhaps Mr. Schmidt can a little bit here, but I believe, given the history that I've seen with the proper rules of Howard.
Is probation supportive of this plea? I know he's been on probation multiple times. Ms. Wood, have you talked with Ms. Burns and consulted them?
I have not.
Ms. Burns, would you like to be heard on this? Do you believe that Mr. Howard would be a good candidate for community supervision?
I'm not sure at this time. I'd have to do some research from his previous cases.
Mr. Schmidt, I'm not asking to hear from you, but I'm welcome to hear from you if you want to say anything.
Well, I couldn't hear most of the state's response. However,
It has to come out. The closer you get, the less they can hear that. So it's got to be away from him and in front of you. Go ahead. Go ahead, Mr. Smith. I'm sorry.
but at this time, we will reserve comment and ask the court to follow the agreement. I think that Mr. Howard, on previous charges in which he was the charge was either dismissed outright by the state as we prepared for trial. He complied with his pretrial release. I do know, and the court knows that I think that the court revoked his bond one time on pretrial. He had been late to sign his jury selection notice, but he did appear. So ultimately, throughout that process that I've known him and that I've represented him on prior charges, he was in compliance with his pretrial release, substantially in compliance, minus some tardy resigns or reset notices on jury selection dates. I think he'll successfully complete his probation, and I don't have any qualms reporting that to the court from our perspective.
All right, I'm going to take a recess in this case and let me think on it, Mr. Schmidt. So
Yes,
if
sir.
Mr. Howard have a seat and I'll call you back up. Who's next, Mr. Schmidt?
This is Nathan Quappel.
All right, this is cause number CR 22-220, State of Texas versus Nathan Allen Coffville on motion to revoke. Are we doing a plea today, Mr. Schmidt?
Judge, the state's going to tender a motion to withdraw a state's motion to adjudicate and continue. We've got amended conditions of probation that basically requires 60 days as a condition of community supervision, extend for 1 year and continue on probation.
Okay. Mr. Coffville, tell me briefly why I should put you back on probation, considering your violations and such.
I've completed numerous probations and I was up to date on my community service and my fines while I was on this probation. And I just got to choose better people to hang out with. The main thing. But I am going to a recovery center in Tyler when I leave here for a year. It's a discipleship program. And I'm trying to get on with the, excuse me, my spiritual journey. Complete that. Get on with my life.
Okay. I'll tell you, Mr. Coffville, I hear that excuse all the time. I've just got to find different people to hang around, or I'm hanging around the wrong people. But unless people are making you commit crimes, and if they were making you commit crimes, you wouldn't be guilty of committing the crime, right? So that means that you're committing the violations of your own. You're choosing who to hang around. You're choosing the conduct that you're doing. It has nothing to do with the people around you. Because as people, we have the ability to make our own decisions. I could be just like you. I could go out and pick people I want to hang out with and do. I can do the same things they want to do. I can be a bird of a feather and flock together with those people, but I choose not to. So I really don't buy that excuse of, oh, it's other people's fault. Actually, I think it's quite the opposite. They may even say the same thing about you because you're the one that's locked up here. You're the one that's sitting before a judge and having to get an excuse as to why I should put you back on probation when you told me before that you were going to do what you were supposed to do. And here you are locked up in my jail and I'm having to do more paperwork on you because you didn't do what you were supposed to do. I'm going to follow the agreement and the recommendation of the state today because it's their recommendation. And if you end up back before me, we're not going to do any more plea agreements. We're going to set it for hearing. The state's either going to prove the case to me, or they're going to dismiss the case, or they're going to fail and not meet their burden. One of those three things will happen. And then if they prove the case to me and then it's my job, then I'm going to do my job. You understand?
Yes, sir.
You hear what I'm saying? I want it to be loud and clear when
Yes,
you
sir.
leave here. Are you sure that this is what you want to do?
Yes, sir.
All right. Court will grant the state's motion to withdraw, the state's motion to adjudicate. Court will extend Mr. Coffville on community supervision for an additional 1 year. Court will order him to serve 60 days confinement in the county jail as a condition of community supervision. The court will give him credit for that time already served, as indicated in the order. Court amends his conditions to include an additional financial obligation of $500 for attorney fees. All right, Mr. Catfill, I'm not going to say good luck because it ain't about good luck. It's about good decisions. So I hope you make them.
God bless.
All right, who's next?
This is James Weatherford.
All right, this is State of Texas versus James Carroll Weatherford. Cause number CR 23194, motion to revoke. What are we doing on Mr. Weatherford?
Judge, we're asking the court to grant the state's motion to withdraw and continue with amendments to his condition of community supervision. Most specifically that he submit to period of confinement at the substance abuse felony punishment facility.
Mr. Weatherford, do you have a drug problem?
Pretty much all my life, you know.
And do you want help with that drug problem?
I'm an old man, I'm tired of it.
If I approve this agreement and we send you down to safety, are you going to waste my time and waste their bed?
I'm gonna do my best, Your Honor, and the halfway house is the biggest part of me having a place to stay and get a job.
Well, the biggest thing for you is to not do methamphetamine or whatever it is.
That's what I'm saying.
The other two things will take care of themselves if you will take care of the methamphetamine
We'll give it
problem.
100% effort. I'm tired of it, Your Honor.
All right, I'm gonna give you this opportunity, but I better not hear about any bad conduct down there or you being kicked out, because if that happens, it's gonna be bad news for you back here. You understand?
Yes, sir.
All right, court grants the state's motion to withdraw, the motion to adjudicate. The court will continue Mr. Weatherford on community supervision, amends his conditions to include substance abuse felony punishment facility, rehab, and the court will order that his financial obligations be amended to include an additional attorney fee of $500. All right, Mr. Weatherford, I expect you to go down there and work your butt off.
Yes.
Who's next, Mr. Schmidt?
This is Nicholas Venture.
What are we doing on Mr. Fincher today?
Judge, we're gonna ask for a reset on Mr. Fincher for another 30 days. Give me an opportunity to spend some more time with the state. I've also had Mr. Fincher as a trustee who works in precinct 3. I've had a hard time tracking him down. So we could sit down together, but we're gonna ask for a reset for October.
All right. The court will set Mr. Fincher for a final hearing on his motion to revoke October 31st at 1:30.
Thank you, Your Honor.
You're welcome, sir.
Fine.
Who's next?
Plenty of.
This is cause number CR 22-166, State of Texas versus Monty Travis Austin. Motion to revoke. Go ahead, Mr. Schmidt.
That's correct, Judge. We're gonna ask for a reset on Mr. Austin as well. Been in conversations with Mr. Hartwell. I do believe that there were some new offenses that the DA's office intended to take grand jury tomorrow. After my discussion with Mr. Hartwell, he's agreed to postpone that presentment. And we intend to debrief with the state, with me and Mr. Austin in attendance after I get back from, I'll be out next week, but we anticipate getting together after that. And then I think, depending on the results of that debrief, we'll have a result for the court.
Okay. Court sets Mr. Austin for motion to revoke hearing October 31st at 1:30.
Thank you.
And Judge, I think, I had, Brandon, Creel. And I'm sure the court's been notified that he was evaluated today, and I've asked him not to be brought. I think Ms. Taberhan has already reset his motion to October. And the court's taken appropriate action on his incompetency.
Yes, sir. Ms. Abraham did indicate to me that Dr. Ingram was in the course of conducting an evaluation on Brandon Ashley Krill in cause number CR 23158. She also relayed to me the information you provided about his behavior and your request not to bring him before the court, and also getting information from Dr. Ingram that he believes that he may be a candidate for forced medications. The court is waiving his appearance here today, and we've reset him to November 12th for status of the competency evaluation and any other reports from Dr. Ingram.
Yes, sir. Thank you. And that would leave me with Mr. Howard as my final case on your docket this afternoon.
Okay, I won't hold you over long.
Thank you. Yeah, you're done.
Thank you. I
Yeah,
appreciate it.
thank you.
Is Mr. Manning ready on any of his, or is he still working, Mr. Abraham?
He's ready.
Okay. Mr. Manning, who would you like first?
Judge, we can start with Mr. Campbell.
Robert Baker Campbell, CR 19108. We're set on the motion to revoke today.
Yes,
And
sir.
I know you have provided some information to the court and state, but go ahead and put that on the record, what your request is.
Yes, Judge. We have been in speaking to the probation department yesterday and finding out some information from the DA's office on Tuesday. I believe we have a potential resolution for Mr. Campbell's case through Veteran Services, be able to get him assistance in being successful on the probation. Over the course of lunch, I have been emailing with the directors or coordinators for the Valor program, as well as coordinating with Mr. Campbell's folks on the outside to try to coordinate necessary documentation to get him into a program. My concern is, and what I relayed to the court, to the state, was that the information that I have does not permit him to go to the program today. And until we get finalization of that acceptance, I think it would be best to reset his case till next Thursday. I've assured Mr. Campbell that I will have an answer for him one way or the other. I've also, as I said, as of just before court, the indication from the Valor program was that he qualified for their program, but they do need his DD 214, and that is the document we're trying to track down right now for his admission into that program. Additionally, Judge, through talking to Mr. Campbell's outside contacts, he's also been accepted to another program if we're unable to qualify for Valor program. That may be an option, is a longer term program. We have several irons in the fire. We just need additional time. I believe we have court next Thursday. If we can have a short reset for me to gather that information to go over it with Mr. Campbell, I believe that we'll be able to get something resolved.
Any objection from state?
No objection, Your Honor. Thank you.
All right, court sets Mr. Campbell Thursday, October 3rd at 1:30.
Thank you, Judge. And Judge, if for whatever reason I'm able to get that information and intake process completed and we get an agreement, would it be possible to handle that business before Thursday, possibly on the Tuesday docket, or if it's just an amendment, whenever it's done?
Yes, sir. Either or.
Thank you. Judge, ready on Jaquavian Jackson.
Court calls number CR 21-361, State versus Jaquavian Antron Jackson. Motion to revoke. Go ahead, Mr. Manning.
Judge, we have a agreement on bond for Mr. Jackson. There are some additional matters that need to be taken care of, and so the state has agreed to a reduction in his bond so that he can make bond on this case. I anticipate we'll be able to get that paperwork to the court before the end of docket today.
What's the agreement on bail?
It's reduced to a $500 cash or surety bond.
500 cash or surety?
That's correct, Judge.
Okay. All right, very well.
And Judge, may we reset his for the next contested docket?
Mr. Jackson is set for October 31st at 1:30. If he's on bail, it'll be at 9 a.m.
Yes, Judge. Yes.
Who's next?
Judge, next ready on Mr. Kevin Parker.
Kevin Winford Parker, cause number CR 24-184 for arraignment.
Yes, Judge. My client and I have reviewed not only the indictment in the case, but the discovery. He pleads not guilty. His name is spelled correctly. He understands the charge against him and requests to be set on the pretrial docket.
All right, court finds that Mr. Parker, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial hearing. Mr. Manning, my next available non-evidentiary Thursday is October 17th. That's only 3 weeks from now. That's probably not enough time for you. Otherwise, you do November 14th.
Actually, that'd be great. And I know that Mr. Parker's co-defendants cases are have been resolved or in the process of being resolved. And I have a feeling that may result in us being able to get Mr. Parker's case taken care of as well. So the sooner the better would be fine. I'm fine with the 17th.
Okay. All right, court sets Mr. Parker then for pretrial October 17th, 1:30.
Thank you, Judge. Judge, if we can call Mr. Christopher Richardson.
Christopher Michael Richardson, cause number CR 23-225. Status, I believe. And it might have been status on getting him back from TDC. So go ahead.
Yes, Judge. And as of Tuesday, when I checked, he was not here. Yesterday, I was in court all day, and so I was unable to come visit him, but he is here. So if I may get him reset, have an opportunity to speak to him about the situation of his case. If we want, we could probably reset him to next Thursday. That may give me some time to go over his case tomorrow and see if we can't reach some sort of resolution.
Any objection from the state?
No objection, Your Honor, although I'm not sure if Mr. Richardson has been arraigned.
I'm sorry, I didn't know what the state had to say.
He said he wasn't sure if Mr. Richardson had been arraigned. Let me look.
He is not, at least during the course of my representation.
All right, Mr. Manning, I'm gonna display the indictment for you and we'll go ahead and go over that arraignment process for Mr. Richardson.
Judge, my client's name is spelled correctly. He understands the charge against him as well as the range of punishment. His plea is not guilty and he requests to be set on the pretrial docket.
All right, the court finding that Mr. Richardson, having waived the formal requirements of arraignment, enters his plea of not guilty into the record. Court sets this matter for pretrial hearing and you wanted, did you want the third? Is that what you wanted, Mr. Manning? Or do you want to set it out further?
Judge, actually, if we can set the 17th, my client brought up a couple issues that I want to pursue a little bit further.
All right, court sets Mr. Richardson for pretrial October 17th at 1:30. Mr. Manning, if you don't mind, let me talk with Mr. Schmidt real quick.
Absolutely. Judge.
All right, I think what I would like to do is I would like to sleep on this. I'd like to reset him to next week.
Yeah.
So are you gone next week?
Yeah, I'm going next.
You're gone next week? Will you be back on the 15th?
Yes.
All right, I'd like to take it in consideration and under advisement until October 15th. Let me sleep on it. Let me consult with probation department. I think the state needs to consult with the probation department. And I'll tell you this, Mr. Schmidt, if I decide that if I decide to accept the plea, then what I would consider doing is giving Mr. Howard a personal bond while you're out, so that while you're out and unable to do the plea, we can give him a personal bond and have him report back to court on the 15th so that he's not held any longer. So it's not going to take me that long to, but I do want to do some research and I do want to have some discussions with the probation department.
Yes, sir, I understand. We'll do
All right,
research.
I know that's not what y'all were expecting, but I appreciate your understanding.
Thank you.
All right, so court sets Mr. Howard October 15th, 2024 at 1:30. Sorry about that, Mr. Manning. Who are you ready on next?
Judge, next ready on Mr. Joshua Mulder.
Joshua Daniel Mulder, CR 24195. Mr. Mulder, is he entering a plea today?
He is, Judge.
All right, Mr. Mulder, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can lower your hand. Your name is Joshua Daniel Mulder, is that correct?
Yes, sir.
And Mr. Mulder, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
Do you feel like you've had enough time to review your case with him and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you have read and signed today that you do not understand?
No, sir.
Mr. Manning, you believe Mr. Mulder to be competent?
I do, Judge. He and I have had the opportunity to discuss this case in depth. He's been able to assist in his defense, leading to this resolution.
And is it my understanding that the original charge is the charge that's on the docket? It's a misdemeanor, a Class A misdemeanor assault, bodily injury, family violence?
Your Honor, he was originally arrested on a assault family violence with previous conviction. Looking at his criminal history, there was no previous conviction. However, because me and Mr. Manning had discussed the case at length, we decided in this court, since we already involved facts and.
So it was originally filed up here, you're saying,
Yes, Your Honor.
as an information, or was it indicted?
As a.
Okay. All right. All right, Mr. Mulder, you are charged by information with a Class A misdemeanor assault causes bodily injury of a family member. A Class A misdemeanor does have a range of punishment of up to 365 days confinement in the county jail and a possible fine not to exceed $4,000. I see the plea agreement and recommendation of the DA's office is that the court hear the evidence, the court find that there's enough evidence to convict you, that the court finds you guilty today, that the court assesses your punishment at 80 days confinement in the county jail, giving you credit for all 80 days of time served, and fining you $500 and fines $270 in court costs and $515 in reimbursement fees. Mr. Mulder, is that your understanding of the plea agreement?
Yes, sir.
And Your Honor, I'm
Go
sorry.
ahead, Mr. Go ahead.
Before we proceed, one thing that came to my mind as I was going over the paperwork with Mr. Mulder, Mr. Mulder is planning to plead guilty to the assault. An assault did happen. We do disagree with the manner and means of how that is alleged in the information, but he is pleading true to the assault. He recognizes that assault did happen. Just by way of making sure the record's clear.
Well, let's kind of discuss that further. Look at your stipulation document. If I'm not mistaken, doesn't it say that he's pleading true as to how it is pled in the information? If it's
Yes.
not, then I would suggest you and the state getting together and discussing whatever your agreement is on that.
Yes, Judge. This was the first I was able to see of the information when we got the plea paperwork today. As I discussed before, during the course of this interaction with the complaining witness, the assault did happen, and that's recognized by my client. He wants to take responsibility for that. If the court and the state don't mind interlineating, we can amend that language to follow the statutory requirements and to meet the factual basis, or if we want to proceed as alleged in here, we can do that as well.
Your Honor, I have no objection to interlineating the late information.
Do you hear Mr. Hartwell?
I heard no objection, but I couldn't hear what he didn't object to.
He said he has no objection to the information being interlineated, but what is it that you're wanting to interlineate in place?
It says that he struck her in the head with a mirror, and that wasn't entirely true.
What is he going to be pleading to? What would you have the stipulation read that he is pleading guilty to that would amount to legal sufficiency for assault family violence?
I believe there was a push or a shove that occurred during the course of their interaction that night.
All right. Any objection from the state?
No objection to amending the information reading, pushing and or shoving.
Okay. In the court, Mr. Manning, did you hear that Mr. Hartwell's made an oral motion to amend the complaint information to recite the facts that you have stated on the record?
I did hear that, yes, Judge.
And so you have no objection to that?
No objection to amending the information to include that he pushed or shoved her, causing injury.
That he pushed or shoved. So do me a favor, just in the stipulation of evidence, I want you to write in there. I know that the facts are not alleged in there, but if you'll just write the language in there, so when the paperwork comes back to me, I'll have the exact verbiage. The The court hereby grants the state's oral motion to amend the complaint and information. All right, any other issues, Mr. Manning?
No, none from defense.
Okay, all right, so Mr. Mulder, I'm going to ask you at this time, understanding the range of punishment in the plea agreement, how do you plead to assault causes bodily injury of a family member?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt. Mr. Manning, any objection to that stipulation as amended?
No, no objection to the stipulation as amended.
All right, that is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that, the victim is supportive of the.
Thank you, Mr. Hartwell. Anything further from the defense?
Rest in close, Judge.
All right, then. The court finding that this is a Class A misdemeanor, considering the evidence contained in the stipulation of evidence and the defendant's oral confession, the court hereby finds that there is sufficient evidence to convict Mr. Mulder of this offense. The court follows the plea agreement and recommendation of the DA's office. The court hereby convicts Mr. Joshua Daniel Mulder of assault causes bodily injury, family member, assesses his punishment at 80 days confinement in Van Zandt County Jail, issues him credit for time served. The court orders him to pay a $500 fine, $270 court cost, $515 in reimbursement fees. All right, Mr. Mulder, you hereby remanded to the custody of the sheriff so they can carry out the terms and conditions of the sentence. When you are released, I need you to contact the district clerk's office or come in. If you cannot pay your fines, court costs, and reimbursement all at one time, then you need to come to the district clerk's office and speak with them about setting up a payment plan, because your failure to pay those things could result in the court issuing a warrant for your arrest. Do you understand?
Yes, sir.
All right, step over to be fingerprinted.
Judge, next we're ready on Mr. Richard Bostic.
All right, this is cause numbers CR 24-126, CR 24-127, State of Texas versus Richard Tyler Bostic. Mr. Bostic entering a plea today.
Yes, Judge.
All right, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, all right, you can lower your hand. All right, I already see an issue with this order of deferred adjudication. There cannot be a finding on the deadly weapon. Doing so prevents me as a court from issuing a deferred.
I'm sorry, Judge. I was focused on something else with the paperwork. I did not see that.
It's okay. We'll go ahead and go forward. Mr. Bostic, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me what that is?
Manic, bipolar and depression.
Are you currently on medication or treatment for that?
Yes, sir.
Do you feel like you have a rational understanding of what's going on in court here today?
Yes, sir.
And you don't feel like your mental health issue is causing you any type of confusion, is that correct?
No, sir.
Okay, and you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
And he's explained to you your rights and you don't have any questions about any of the paperwork you've read over and signed, correct?
No, sir.
Okay, Mr. Manning, do you believe Mr. Bostic to be competent?
He is, Judge.
And you've explained to him his rights as they pertain to this case and also the advantages and disadvantages of a deferred adjudication plea?
I have explained this, Judge, and he does understand what's at risk.
All right, Mr. Bostic, you are charged by indictment with a second-degree felony offense of aggravated assault with a deadly weapon that does carry a range of punishment of not less than 2 years or more than 20 years confinement in prison and a possible fine not to exceed $10,000. I see that the district attorney's recommendation is that the court consider the evidence, defer a finding of guilt, not place you on or not convict you rather, but rather to place you on community supervision or probation for 4 years. And they're recommending a $1,000 fine along with court costs of $290 and reimbursement fees to the county of $520. And also in addition to that, the DA's office is recommending that the court dismiss their other indicted case, burglary of a habitation, intending other felony in cause number CR 24-127. Is that your understanding of the plea, Mr. Bostic?
Yes, sir.
All right, understanding the range of punishment and the plea agreement, Mr. Bostic, how do you plead to aggravated assault with a deadly weapon?
Guilty.
And are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
And has anybody threatened, forced, or pressured you to plead guilty?
No, sir.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection.
Stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. State is in compliance. We have not been able to make contact with the victims despite several events.
Okay. And is there more to the story that would justify this type of plea, considering the use of a firearm and a threat?
Yes, Your Honor. So, the offense took place back May 15th, 2022. Warrant was issued for Mr. Bostic's arrest immediately. So in that 2-year period between the event and the filing, the warrant had been unserved. So Mr. Bostic kept himself out of trouble for that 2-year period. I'm not sure exactly what led to Mr. Bostic, the warrant actually being served on him. But that 2-year period of presumably lawful behavior, along with just the other surrounding factors, difficulty getting in contact with victims, Your Honor, is why this is the agreement.
Did you hear that, Mr. Manning?
Parts of it, yes, Judge. I also I can add for the record, I spoke to Ms. Burns, and probation is in support of this plea. Additionally, Judge, the facts of this particular case, I think, gave issue for possible defenses to be raised and reasonable doubt to be created. However, my client decided that he would, given this plea, much rather resolve this case as such instead of going forward with a jury trial and having a jury make a decision on the facts as they were alleged by the state.
All right, thank you, Mr. Manning. Thank you, Mr. Harwell. All right, then, considering the evidence, court will follow the recommendation of the DA's office. Court finds that there is sufficient evidence to convict Mr. Bostic of this offense. The court will follow the plea agreement. Court defers a finding of guilt, places Mr. Bostic on 4 years community supervision, orders him to pay a $1,000 fine, $290 in court costs, $520 in reimbursement fees, and the court dismisses under section 1245 indicted cause number CR 24-127. All right, Mr. Bostic, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted, and after that, you'll talk with the probation officers about what's next, okay?
Yes, sir.
And Judge, just to let you know, I did get a corrected copy of that judgment, and it is included in the plea paperwork that we completed.
Okay, good, thank you. Who's next?
Yes, Judge. Miss Bukosby.
Crystal Bukosby, CR 19107.
Judge, Ms. Bukosby was being housed or is being housed out of county, and I was unable to speak to her the last couple weeks that I have attempted to. regarding her motion, I would appreciate the opportunity to reset this case, as it is our first sitting on her. With me is her attorney, reset her case in order for me to, discuss with her, the allegations as well as the possible resolutions for this case.
All right. Any objection from the state?
No,
Do you want to set it 17th or do you want something sooner?
May I have just a moment to speak to my client?
Sure.
Judge, I believe if we set it for the 17th, based on some of the information that Ms. Bacosby provided to me, I think we might be able to get some type of resolution figured out.
Okay. Court sets Ms. Bacosby for hearing on the motion to revoke October 17th at 1:30.
Thank you, Judge.
Yes, sir.
May she be excused?
Yes.
Thank you, Judge. Judge, I need a brief moment with Mr. Graves. If you want to take up, there's one other female here. If you want to take that up while I handle his.
Yes, that's fine. We're going to conduct a hearing on a capious profile, so it can be off the record. All right, Ms. Harvey, my name is Judge Chris Martin, and this is a hearing on your capious profile, which means it's a warrant that was issued for your failure to pay court costs. Are you aware of that? I'm sorry, I couldn't hear you. Do you understand why you're in jail and what we're having a hearing about today?
Yes, sir.
Okay, so it appears that back in 2017, the court signed a judgment in a criminal case, and you had fines and fees that you were due to pay, and it's showing that you owe, I believe, $1,892 in court costs, unpaid court costs, and fines and fees. Are you able to make a payment towards any of those? I believe that the court previously sent letters out, collection letters, and trying to get you to pay this without having to issue a warrant, but we never heard from you. So that's why you're here today. Do you have any financial ability to make any kind of payment towards this, what you owe, this delinquency?
Not right now, no.
Not right now? What does that mean?
I don't even have a place to live at the moment, much less money.
Are you homeless?
Yes.
And how long have you been homeless?
Since my houses got burned down August 2nd or 3rd.
Your home burned down this August 2nd, the 24th?
2 of them.
2 homes? At the same time or different times?
In 1 week. And I got locked up in the same week.
And say that again?
I got, in 1 week, my family burned down both my houses.
So somebody committed arson and burned your houses down?
Yeah.
Who did that?
I'm pretty sure it was my dad and my brother-in-law, but I wasn't there.
Were they arrested for it?
No, they said it's too hard to prove.
Are you working at all?
No, not right now. I've been trying to get a job, but I'm having trouble getting one in Grant Saline.
Ms. Harvey, have you been arrested since 2017?
I got arrested in the same week that my houses were burned down for assault.
Okay.
Oh,
Anything,
my bad.
anything else?
No. Well, yeah. Like maybe some ticket since 2017.
17.
No, I don't think I've been to jail since I got out of prison till August 3rd.
All right, Ms. Harvey, I'm going to cut you a break today and I'm going to waive your fines and fees.
Seriously? Thank you.
Yeah, I'm gonna do that and I expect you to go get a job, find a place to live, go get a job and stay out of my jail.
Yes, sir.
All right,
Thank you.
you're welcome. I'll get an order sent over there soon.
Thank you. Oh, God.
All right, Mr. Manning, you ready with Mr. Graves?
I am, Judge.
All right, so Mr. Graves entering a plea today.
He is, and there may be an update to the judgment that you have. The judgment we had did not have Mr. Graves' credit time.
Yes, mine either. Go ahead.
They calculated his credit time as 286 days.
Okay, 286. Okay.
That is correct.
Any other changes?
No other changes. I would just like to clarify that while on the judgment, there are 3 cases that were taken into consideration. There's actually 2.
I do have copies of several dispositions, like rejections.
That's correct. 11 or 12 additional dispositions beyond that, those 3 listed in the judgment.
Yeah, let's make sure that we're on the same page. I'm going to give you the DA prosecutor number.
Yes, Judge.
I've got 2024 106, 107, 109, 110, 111, 112, 114, 115. I was out of order on one of them. Also 113. 117. 269, 323, 324. So look right.
That is correct. That's all the dispositions that I have.
Excellent. All right, Mr. Graves, sir, raise your right hand. I'm going to place you under oath. Do you swear that the testimony you give to the court today would be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand. Is your name Stephen Ford Graves?
Yes, Your Honor.
And Mr. Graves, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you?
Yes, sir.
You understand everything in your paperwork that you've read over and signed today?
Yes, sir.
You have any questions before we go forward?
No, sir.
Mr. Manning, do you believe Mr. Graves to be competent? And if so, have you explained to him his rights pertaining to this case?
He is competent, and I have explained his rights regarding this case and the collateral consequences.
All right, Mr. Graves, you are charged by indictment with the first-degree felony offense of possession of child pornography greater than or equal to 50 depictions or videos. A first-degree felony does carry a range of punishment of not less than 5 years or more than 99 years or life confinement. in prison and also carries a possible fine not to exceed $10,000. I see that the state's recommendation upon your plea of guilty is that punishment be assessed at 15 years confinement in prison, along with court cost of $290, reimbursement fees of $20. You would receive 286 days credit towards your sentence for that time that you've already spent in jail. And the DA's office is disposing of several unfiled cases, 11, I believe, that are included here in the plea agreement that Mr. Manning, your attorney, and I have gone over and discussed all of those unfiled DA cause numbers. Is that the understanding that you have about your plea as well?
Yes, Your Honor.
Okay. All right. So Mr. Graves, I'm going to ask you at this time then, since you understand the plea agreement and the range of punishment, Mr. Graves, how do you plead to possession of child pornography greater than or equal to 50 depictions or videos?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, Your Honor.
And Mr. Graves, has anybody threatened you, forced you, or pressured you to plead guilty to this crime?
No, Your Honor.
Court does accept the defendant's plea of guilt at this time. Mr. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
Okay, stipulation of evidence is admitted and the court does take judicial notice of Mr. Graves' judicial confession. Anything further from state?
Nothing further on that.
Anything further from the defense?
Press and close, Judge.
All right, court's going to review the stipulation of evidence. All right, court having reviewed the evidence finds that there is sufficient evidence to convict the defendant of this offense. The court follows the plea agreement and the recommendation of the DA's office. The court hereby convicts Stephen Ford Graves of possession of child pornography, a first-degree felony, assesses his punishment at 15 years confinement in the Texas Department of Criminal Justice. The court assesses court costs of $290, reimbursement fees of $20. Further, the court does dismiss under section 1245 cause numbers CR 24-53, online solicitation of a minor, and DA 2024-106, 107, 109, 110, 111, 112, 113, 114, 115, 117, 269, 323, and 324. Court awards Mr. Graves 286 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Graves, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Good luck to you,
Thanks,
sir.
Your Honor.
You're welcome.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning. Appreciate your work today.
Thank you, Judge.
Mr. Abraham, anything else that we have pending that we need to take up?
No, sir, not to my knowledge.
Okay, I'm gonna go work on that order for Ms. Harvey.
Okay, or I can do it when I get back. You want to?
Gonna remain there to sign these papers?
Yes, he will remain there to sign these papers, as long as you're fast.
Are you coming back?
Why would
Why
you
don't you
ask
just
me-
come back?
why would you ask me such a question? Why would
You
you ask-
always leave me.
Well, I'm not married to you, so I can leave you.
That is true.
Yes, I will come back and I will sign your documents. Because you're such a good worker and you're so kind. All right, if there's nothing further, then we're adjourned.
And did y'all take care of the other at 1:30?
Oh, yes. So I didn't tell Mr. Manning. So Deputy Martinez indicated to me that Ms. Simpson left the probation department without giving a sample. And I do not believe that she is here at this time. So the court is finding her bond to be, or her bail to be insufficient. And the court will be issuing a warrant for her arrest.
We will tell Mr. Manning. Maybe.
Yeah, you might want to catch him before he gets too far.
Okay. If you see Jonathan, will you stop it?